Welcome to our Care Compass project. This is our first quarter presentation, and we meet quarterly to discuss educational issues and concerns regarding the best practices in caregiving. Our session today is going to focus on estate planning and advanced care directives. I'll turn it over to Phil to share information with us.
Thank you, Mother. Hi, good morning, everybody.
Good morning.
As I said, I have the enviable position to greet everybody, but the unenviable position of being between you all at lunch. So hopefully it'll be a brisk, informative, about 35 minutes, and then we'll have some time for Q&A. And then obviously I will happily stay after folks have specific questions that we want to be a little more maybe confidential about talking about as opposed to discussing it in front of everybody. So my name is Phil Wylkan. I'm a certified elder law attorney. Our presentation today is called Taking the First Step, Estate Planning Basics. So basically the conversation today will be about kind of what can we do, what's out there, what issues should I be dealing with as I either dip my toe into getting planning done, or maybe I did it some years ago, or I'm finding about things I could or should be doing. And so this is a good way to just kind of issues. This is something maybe I should be thinking about. Either you already have, I'll give you a little information about it, or you haven't been thinking about it and a light bulb will go, oh, I gotta think about that. I gotta talk to somebody about it. So the idea is to really touch over a lot of topics in a short period of time. This is not going to be going deep into wills and trusts and all that stuff. If you want to do that, I'm happy to chat with you about it because it's what I do. So I'm happy to discuss it further, but for this conversation, it's going to be really kind of a little different topic to kind of get you thinking about what you need to be doing. Let's see if I get the click of the word. Maybe it is, and maybe it's not. I may need you to advance for me. Oh, there we go. Oh, I look so young now. See, that was before I had 4 children from 19 to 8. And now I can name this is a Jacob patch and this is a Mina patch, you know, on my gray beard. So a little bit about me. I'm a board certified elder law attorney, certified by the state of Ohio as well as the National Elder Law Foundation. I got my law degree from Lewis and Clark Law School. I grew up in New Jersey, so I just split the middle and moved to Ohio. So we've been here I've been here since 2005. My mother-in-law married a fellow from Fremont. We came to visit and kind of never left. Whether they think that's a good thing or a bad thing, it depends when you talk to them about it. But I live in Fremont with my 4 children and my wife. We also have an office in Maumee, and I do lots of traveling when I meet with folks. I know a lot of seniors need help. I come to them, so I can come to senior centers to do what I do. Also a member of Lawyers with Purpose, which is a group that helps us stay on top of all sort of legal changes. They help us with documents, help us with planning, keep us kind of educated and informed on how to best serve the public. Oh, that's not want to go to that. Let's see. Want to go to that thing. Is there another clicker I should be hitting? Maybe this one. I'll try that one. Oh, that's the clicker. I'll just have you. It's okay. I'll just tell you when that's okay. So once again, I'll click again. So board certified elder law. There's fewer than 400 of us in the country. And we know we have a lot of lawyers in the U.S. A lot of this when somebody raises their hand and says too many, and I don't always disagree with you. And then there's 27 who are certified in elder law in the state of Ohio. So that doesn't mean all attorneys can't handle estate planning and elder law. They can. Just by being certified means that academically you kind of reach some levels and goals to give people a feeling of security when they come see you. So we're one of 27, and we're happy to be there. And we're the only ones typically in Northwest Ohio. So those are folks who in other places, folks in Dayton and out towards Lorraine, but we're the ones kind of in this corner. We also have a website, so check out our website if you want further information, wylkanlaw.com. In fact, the packet that you have has some places for notes, has some information about our firm going forward. So let's talk about planning. There's 3 main reasons that I see why people don't plan. First one, procrastination. You can see the note, it says the to-do list, it says what? To do the to-do list, right? How many people in here procrastinated? Oh, you raised your hand. I thought you'd do it later when I get to it. So the idea is we put off planning because it deals with when people are sick. What happens when I die? What happens if I go in a nursing home? And the technical term for that is icky. We don't want to talk about icky stuff. And you think you don't want to talk about it, bring it up to your children. You want to have a conversation, screech a halt, like, you know, when the turntable would screech and everybody would stop. That's a planning conversation with your children. They don't want to hear about what happens if you die. And so we kind of put it aside. We do other things. We keep our lives busy with other matters and put this aside. Other thing is lack of knowledge. You know, people think, well, I don't know what to do or how to do it. Or we have dinner and people tell me what their cousin did in Arkansas. Well, the law's a little different in Arkansas. The rules are a little different in Arkansas. And so what happens is we get overwhelmed and we do nothing. We just shut down. So we call that paralysis by analysis. We just shuffle it away. The last reason is denial. I have a picture of an ostrich there. What does an ostrich do when it's scared? Correct. Somebody called me out years ago that said, that's not what ostriches really do. And I told them my biology is known from Hanna-Barbera cartoons. And we're going to stick with that. When your head's in the sand, what's sticking up in the sky? We're PG, so we can do, as they say back home in New Jersey with some of my Jewish friends, your tuchus is in this. And when your tuchus is up, you get a free kick. So a lot of what planning is empowering you to make sure the results are what you want and the world doesn't get a free kick. So we don't want to be in denial. We don't want to be the ostrich. You want to take care of these things in a way that is what you want. The law provides many opportunities to arrange your affairs for your advantage and protection. But two things. I already told you about my 4 children, 19 to 8. Completely my fault, right? I can't complain about that. But I don't know about you, but my kids have gotten into fights in the past. Your kids were probably all perfect angels. They all sitting there with their Bibles and being present. My kids not so much. And when they get into fights, they say, hey, he did something or she did something, and somebody did something first, and we say 2 wrongs don't what? Make a right. And what I do for planning, 2 rights make a right. Do it right and do it in writing. Okay. So it doesn't matter if you draw it randomly on a scrap of paper, you didn't do it right, it doesn't matter. You don't put it in writing, you just tell your kids, hey, you're in charge when I die. Not gonna get done either. So make sure you do it right and do it in writing. And it's okay because what's right now may not be right 10 years from now in terms of the law or in terms of what your wishes are. So make certain it always reflects what you want. So seniors and their concerns, my basic story with the family we talk about are Bill and Mary Smith, and we talk kind of about what their struggle is. Today we're going to focus on all the things that can happen with this couple in their lives that need to be addressed with some sort of planning. So we'll look at the big picture. So we've got documents. What documents should we have? In fact, today you're going to have an opportunity to prepare some documents for your healthcare with our other speaker. Long-term care, biggest concern for my client, the nursing home, the cost of assisted living, the cost of care at home. How do we plan for it? What happens if it's too late and somebody's already in the nursing home? Are there things we can do? And yes, there are. You just have to talk to somebody who knows what they're doing. What happens when I'm gone? Is that established? We know where things are going. Do I have changes? Did I do a will 30 years ago when my kids were this big and I didn't include them in any decision making? Well, now they're 30. They still shouldn't be involved in decision making, but maybe they should. So we have to update that. Okay? Have we named trustees for a trust or executors for a will for brothers and siblings and uncles who are no longer with us? And so the documents are now outdated. They don't serve any purpose because they don't have anything in there that's important. Management. Who manages my affairs if I'm incapacitated or when I die? Who's in charge? I may have that son who I think is really, really important to take care of him. I could have that special daughter. It could be that I picked the kid who still lives in town and is unemployed and is over all the time. Well, maybe not the best choice just because they're present. We often think, well, they're close by. So who's going to manage things if I need help with that? And with technology, it doesn't necessarily have to be the closest child. It could be somebody who's a state over or a few states over. I have folks who are managing finances for their parents from California. So we don't always have to run to the most present person if maybe they're not the best person. And that can change too, right? Maybe my son was a great choice 10 years ago. 3 divorces and a bankruptcy later, maybe not so much. We want to make sure that our documents reflect the status of our lives going forward. And it's not one of those, we do it, or Mr. Ron Popeil, you set it and forget it. The state plans aren't like that. You have to kind of review it, make sure if my life has changed or the law changes, make sure that I'm getting the maximum protection I should be getting, and not left with your head in the sand and your focus in the air. So we're going to talk about some subheadings under here too for each one. I'm going to touch on them very briefly. So I'll have Danielle clicking for me really well, so I appreciate your help. So management. Who helps manage your assets in healthcare if you become disabled or pass away? Okay, 70% of the country doesn't have a will. Okay? I'm not judging anybody in this room, so I'm not going to point, hey, do you have a will? Do you have a will? But the idea is 70% doesn't even have that. Even less so when it comes to management, which is what we talk about, powers of attorney or trust to help with incapacity. And that's the bigger concern sometimes, because if I become incapacitated and I'm a single person and I can't manage my finances, I could wind up in what's called a living probate with guardianship. Someone's got to go to the court to get authority to handle my finances. If I don't have things set up properly, I have somebody in charge to manage my finances for me if I'm sick. So incapacity is a big one. You know, what about income tax concerns? What about qualified money, which is my IRA, my 401k? A lot of people say, well, I have a trust and it's all my trust, I'm fine. Well, your retirement assets can't be in the trust. So does your power of attorney give the authority to handle those things? Because those are not assets that can be put into a trust. Special needs, not just for ourselves if we become incapacitated. I have special needs children. So I have a special needs grandchild that I know that, hey, if my child dies before me, you got to plan for that. My youngest is 8. She was adopted at 3 days old. She has disability. She's gonna work with the board of DD for the rest of her life for someone for delays caused by her birth mother when we adopted. So I have in my trust special needs provisions for her. And I got to get all my kids through college before there's anything actually for her. But the idea is that I need to make sure I plan for her because she's going to need help for the rest of her life. I don't want anything we leave her to cause problems. Incapacity, who makes them, when can they act? We want somebody with us right now. Do I need my son or daughter or cousin or nephew to help me out now? Because I don't go to the bank as much as I should, or I don't know online as well as I should, and I just need help. Or I'm not focusing on my finances because of some reason, physical, mental, or both. What about just in terms of incapacity? Otherwise, I dropped an N from that. Your incapacity. No, I only want you to have power when I get sick. I'm okay for right now. I'm very independent. I don't need somebody involved with my story until that's necessary. And what guidance do we give them? Do you want it to be my wishes or my goals? Let them know my spending habits and maybe my opinion about the nursing home. You know, want it, don't want it, try everything but, or you know what? My friends are already there, and when time comes, I'm happy to go there. Some folks are happy to go to assisted living, so all their friends are there. So it depends on what your story is. Income taxes. I love this. This is you can't deduct Starbucks as a workspace. When you go to Starbucks, a lot of people are doing working. Selling or gifting your home, there's income tax perspective to that. Whether you gift your home has income tax implications if you give your home away. If you give it to a child or you give it to a trust, there's different rules that guide that. Investments, annuities, 401k, those types of things. Qualified money, who controls that incapacity of my debt? People like to say my spouse is in charge. No, the IRA is in your name. So just because you have a spouse, I have a spouse, and I would want her to manage any of our retirement funds. I have to empower her to do that because they're just in my name. They can't just assume your spouse has the right to access your funds that are just in your name, even though you're married. And I kind of like her, so I probably want her to help out, give her that help with this. But you can't assume that. It has to be empowered to do it. Who are your beneficiaries? Your spouse, your children, is it going to a trust? Or what are the impacts of doing it? There's a tax-free rollover for IRAs to your spouse. So most folks want to do that. Or do you want to make sure that money goes to your children for whatever? You have a blended family. So what are our concerns with that stuff? Special needs, protection for myself and my spouse, children, heirs. Risk your children or grandchildren losing benefits if they're on public benefits if you leave them well and it's not protected properly. Gift taxes, minor issue, $16,000 per person per year to give things away. Not the same as a Medicaid gift penalty. So folks will say, well, I can give away a bunch of money and the nursing home or Medicaid doesn't care. Those are two different rules. Okay. Gift taxes means I can give away $16,000 per year per family member and nobody really bats an eye. You don't have to do a tax and a gift tax return. So Medicaid will care if you just give away all your money and try to get on Medicaid. So those are two different rules. Do my documents have a cap for gifting? Which could be good for some reason, because maybe you're like, I don't want them to give away all my stuff. Or it could be, I need to do long-term care planning and I'm sick. I need to give away more assets. So my documents allow us to do what we want to do. Once again, 15 years ago, maybe you didn't want a cap, wanted a cap on what could be given away. Now that you're older and looking at long-term care, you may want to say, give your agent the ability to do more things with it than they were to do otherwise. What critical documents? Wills, trust, power of attorney, healthcare power of attorney, living will, a HIPAA release. We're going to get into those healthcare documents with our next speaker. So they will take care of that for us. So when we talk about wills, we're dealing with a guidebook for the probate court. It's written instructions as to where you want things to go if it is subject to probate. So it doesn't avoid probate. Folks will say, I don't need to go to probate, I have a will. No, that's the rule book for probate court. So if that's all you're relying on, you're not avoiding probate if you just have a will set up. States where you want things to go when you pass, has to be properly written and signed. Once again, do it right and do it in writing. That's what a will does. It doesn't avoid probate by doing it. There's other things you can do to avoid probate, but a will's not going to do it. And you may say, that's okay, I don't care. That's why you go meet with somebody, and I say, kind of poke people to ask them questions. Let me poke you about this and talk about it. Like, I want to make sure that you answer the question so you're comfortable with what you have. You'll be perfectly fine with a will plan. That's okay too. But I'm gonna make sure you own it. I want to make sure I ask you questions to make sure, hey, is this really the right fit for you? And if you say yes, guess what? I'm okay with that too, but I'm going to ask you the question to make sure you feel comfortable. Trust. The trust, they avoid probate. And trust, there's different types of trust. And so I could teach a whole 2-hour course. I'm not doing that today, I promise. On trust. Okay. Lots of trust do lots of different things. You have trusts that are for special needs children or grandchildren. You have trusts that are for retirement accounts. You have trusts that are gifts that I'm giving to my children that I'm walling off from Medicaid or from. You have asset protection trust that I want to get income from. You have revocable living trusts, which are trying to avoid probate and maybe just protect distributions to your kids. There's lots of things. Can protect from different income taxes, creditors for your heirs, creditors for you, or special needs. There's lots of diversity in trusts. So just because you have one doesn't mean you know what it does. And it may be that it's time to move to something differently, or to at least have it explained to you so you understand what you did back then. Financial power of attorney empowers your agent to make decisions for you. So this is one of those basic documents we should all have. If I get sick, who pays the bill? Okay, who can sign the check? Okay. Now, if you have a trust, the trustee can do that too, but this is your most basic financial authority document. What powers are you giving them though? Did you have it done 20 years ago and the statute has changed as to what powers have to be enumerated to give them the ability to do it? Okay. Certain counties for long-term care are going through powers of attorney and finding out whether or not you can do planning for long-term care as part of a power of attorney. In fact, this county does that. Wood County is very specific about what powers are in your powers of attorney if you're doing long-term care plan, trying to protect assets for your family or your spouse. How much can they do? Certain powers have to be spelled out, certain powers are assumed. And do your kids know your wishes? Or whoever your POA, do they know what you want? Do they know you want this type of planning or don't want this type of planning? Healthcare power of attorney, we'll discuss that later. What kind of care do I want? Is it spelled out in my document that I want dialysis? For my example, I was a caregiver of my mom for 3 years before she passed. That's why I do what I do. I was 25 years old, only child. She was a single parent. She called me, needed help. So guess what I did? I didn't hang up the phone, I promise. I moved her in with me. And she got the bedroom and I got the pull-out just north of DC where I was living at the time as a paralegal. And that's what I did. We talked this through with her and we did these documents before I went to law school. I didn't know what I was doing. I was trying to figure it out. I luckily had a fiance who's been my wife for 20 years. So that was helpful. We did it together and she was a great support to me. I always tell her she works in the firm with me, but she's not a lawyer. I always think maybe she should have because she's very good at these things. But she was there to help us figure out what my mom's wishes were. We talked to her about it. But unless I know what her wishes are, how can I follow them? It's really daunting for children. Healthcare POA, I'm going to have our next speaker focus on that. Living will similarly. I just like this cartoon I'll share with you. It says, just so you know, I never want to be in a vegetative state dependent on some machine. If I ever happen, just unplug me. Okay. Unplug the TV. And I'm sure during the playoffs, the last couple of weeks for the football, folks, you get that. Shout out, hey, what are you doing? So, and we'll get to they'll do it, I'm sure. So we're going to move on from that. All right. Long-term care planning. We talked about this big concern. Another topic that can be presented on for a long time about various things. We're going to touch on it briefly. How do I pay for long-term care? Well, they'll always take a check. We have insurance, we have benefit placement, Medicaid. I'll go through each one of them briefly. So insurance. Well, if you have long-term care insurance, great. It can be very helpful to kind of help defer some of the costs of long-term care. But it may be too late to get it. If you're in your 80s, it may be prohibitively expensive or impossible to get. This is not health insurance where there's no, there's no pending condition. You don't have that benefit. If you're been a history of cancer and you're trying to get long-term care, they say no. Or they'll say, we'll give it to you, but your premium is going to be super high. So it may be too late to get it. If you have it, what does it cover? Does it cover nursing home, assisted living, maybe home health? Is it a comprehensive policy? Or is a policy you got in the early 2000s that only covers nursing home? How much is it per day? What does it cover? What's a cap? How much does it cover for? The other question is there an elimination period? Do I have to pay out of pocket for 90 days, 120 days before it kicks in? Do I know who the current servicer is? Because I see these all the time. They go from 4 different companies, and I have a policy from an old company from 1998, but it's now held by a totally different company in 2023. So do we know who's servicing it so we can get information if need be? So these are the things to worry about. Veterans benefit, also applies to widows or widowers. So was your husband or wife a wartime veteran? Okay, they qualify for some of these benefits that may be helpful for veterans. There's some help for home health, for assisted living. You can use it for long-term care for the nursing home. It's typically, I want to say right now, it's upwards of $2,500 a month tax-free. If you're the spouse of a wartime veteran, I want to say it's now up to $1,500 or so. The numbers have changed this year. I got to get new tax. Yeah.
Is there a difference between a wartime veteran and
Service? Yes. It's the time frame. So for example, for the VA will have those listed, what time for service. So for example, for Korea, it's from 50 to 55. There's a date in 55, I can't remember it offhand. You have to have been serving. For Vietnam, it's a little different because there's a boots on the ground time frame that's earlier. So if you were actually in on the ground in Vietnam or thereabouts in Southeast Asia, it's like in the earlier 60s, and it goes further out if you were just serving. Because you don't have to have served in that theater. You could be serving in Washington, D.C. in 1952, you still qualify for the benefit. But those dates are pretty important. No, you don't have to be. You don't have to be on you don't be out in the field. You could be a clerk in Germany during wartime, but you would qualify for the benefit. But there's care levels that are important. Income and assets are important as well. Placement. Where do I want to go? Where do I want to be? Home health, independent living. So the first thing would be home health, getting people to come in and help you, maybe to keep you independent and home as long as possible. Most people want that, right? But some folks are really personal about having folks in their home. That can be a real struggle with the seniors I work with, and when I work with children, with their parents as well. But having home health can help you age in place. Taking some of that burden from you so you can be home longer, and it's cheaper. Independent living. So those are places where you have an apartment, maybe that's on the inside. A good example in Wood County is Otterbein, Portage Valley. They just opened they have an independent wing. They have an independent apartments and little condos. I have some clients who live there. And then they have an assisted living wing, which is in the building with an inside door. And that's where they give you more medical assistance. So there's nursing staff on duty to help you. The last one is the nursing home, where you're getting more intensive care all the time to make sure that you're okay. Obviously, each one of them, cost goes up as you go down the list. So do we know what our wishes are? Or do we want to stay home as long as possible? What's the plan for that? We want to get long-term care, or are we having somebody I have a Parkinson's diagnosis. I have a dementia diagnosis. I know it's going to show up. So what's the crisis when that happens? What can we say? What do the rules say? Different for everybody depending on the fact. Medicaid is a federal program that pays for long-term care if you qualify. Income asset. Past gifting is important. We talked about that. You got to be careful. You can't just give all your money away and go on Medicaid. You figure that out. But there's rules that you can follow to try to protect things as best you can. And that'll be the focus in the future. Yeah, how do I arrange my affairs upon passing? Estate administration really takes up probate avoidance. Is that something you care about? You want to be in probate court or not? Some folks don't care. And that's okay that you don't, but I'm going to tell you what it means and whether you want it or not. estate tax protection. Ohio, you've already done a good job. You live in Ohio, no estate tax in Ohio. So congratulations. I give you all credit for that. Now, federally, the exemption is 12.06 million last year. I think it's gone up to 12.5 almost. I gotta double check that for estate tax protection. So it means you have to die with more than $12.5 million. Everybody in this room is very close. I know, so just barely got out of that, but that's the story. So yeah, so estate tax is not really an issue with most of my clients. I have a couple clients who are in that rarefied area, but very few. Special needs protection, protecting for those disabled beneath me. If I have a child who's dealing with disability or I have the possibility of disability. Asset protection. Do I want to have things set up that I'm protecting my assets from creditors when I'm alive or when I'm gone? State administration deals with it. I love this. We're the meats. We're here to inherit the earth. In the scripture, so trust administration, probate administration, beneficiary designation, payable on death, transfer on death, current with rather survivorship. Do I have things set up like that? And what are the ups and downs of those? Because even though that's simple, that may not be the outcome you want. So you can put your kids on things and put things on accounts and have those TODs things. They're easy, they're simple, but they may have outcomes you don't like. We have to double check to say, is this really the answer that I'm looking for? Probate avoidance, you want to lower costs, less time, less stress and hassle, more control. There's no form to argue. You go to a probate, there's a form for everybody to get into an argument with each other because people have to sign off on things and people have to agree to things. And the court is overseeing everything. That may be a good thing if you have an argumentative family, or maybe not if you're just creating opportunity to fight. So there's lots of reasons that probate could be avoided. Estate tax we just talked about, so we're going to go through that one. Special needs, we talked about special needs trust, first party, third party. So we have folks who maybe you have a disabled child and they have their own money. That's first party money. They do a first party special needs trust. Is it money that you're giving to them or leaving to them that you want to make sure is protected? That's a third party story. We have things in Ohio called stable accounts, which are checking accounts or other accounts set up for the disabled folks that it's flexible, can be used by the disabled person, but avoid being countable as resources for long-term for benefits. Asset protection, creditors, nursing home, protection for your heirs versus protection for yourself. So I'll be at the point now where like, you know what, my income is providing quite a bit for me. There's assets I don't necessarily use very often. Do I want to start discussing how I position them to protect that and limit creditor access because I'm not dipping into this account or this amount or this property I have. So I'm going to pass around the quiz. But the idea is what should be the main elder law issue for you and your family? And this is kind of my little joke at the end. The right elder law. Making sure you have somebody who listens to you. And I say this saying it doesn't have to be me. I'm saying make sure that your attorney is dealing with these issues if you have them. Make sure the person you have is addressing all of these concerns that are there because they may not. And they may not realize it's an issue or they don't practice in that area. So always make certain that you're asking those questions. So from our office, we always say the guiding principle of WIIFM. Anybody know what that means? What's in it for me? Right? Why'd you come here today? Lunch, right? I get it, I understand. But you came here because you had an interest or a concern. You're getting a benefit here. When I do planning, of course, it's to work with more clients and run my business, keep my lights on, and hopefully keep my kids safe. But the idea is that's what's in it for me to do good planning to make certain that I can continue to serve clients and help people while providing a living. For you, it should be to make sure if it's important to you, let's make sure your planning addresses it. You may not care a fig about estate planning or about probate avoidance, doesn't matter to you. But I have a special needs child. That means a lot to me. It could be that I am concerned about the nursing home because I've been diagnosed with something. It could be I don't care about that. I'm gonna just, just bury me in the back acre when I'm gone. I don't care. So what's in it for you? What's your driving purpose for doing this type of planning? It's different for everybody. Our focus is on those solutions for those unique things. So a little bit about us. We do complimentary consultations. You want to come meet with me? There's no cost to meet with me. Fixed fees for what I do. It's okay to say no. You're not going to break my heart if you do work with me. I got other people I can help. It's okay. You don't have to like, oh, no, it's not a good fit. So it's okay. That should be that. Any questions? I'll just go through that. So we don't go over that one. Next one. Okay, so we've got about 10 minutes for questions before I get out of here, and she has to go get lunch for everybody, so. I went through those last few slides very quickly, because I know Q&A, you may have things on your mind you want to talk about. So I know we went through a ton of stuff in a very quick period of time. You have questions. It could be about that, it could be something else. Any questions about estate planning, long-term care that you'd like to have answered to?
Well, I think, you promoted a lot of questions.
Yeah.
And-
Well, that's part of the job, yeah.
Yeah, and I wish, and I apologize for being late. Actually, I wasn't sure if I had registered and they told me go anyway. I didn't. Okay, sorry. I'm crashing but I was interested. And I do have some of those things. And unfortunately, I have lost confidence on the attorney that did it for me. So I have a ton of questions on the things that I do have and whether do I need more, because you went really fast.
Yeah, I had to, yeah.
I asked her if there was a printout of your.
I can send one. I just get it this morning, but I can,
It will be posted on our YouTube channel.
I'll give it to her as well.
Okay,
This present, but I can give her a printout of the,
because I forgot, when I saw them, I realized maybe I do need that.
Yeah.
You know, and I don't know, because the attorney that did it for me, did not explain it the way that you did now,
the
so.
light bulb went off over your head.
Yeah.
I gotta look
keep
into it.
going- keep going on.
I saw a couple
So,
of old go off.
I would like to have that free consultation.
Yeah, just in the packet, there's a form to put out your information, and we'll give you a call and have you either come in or work out that I can come to you and we can talk about it. That we can talk about your unique situation that is different for everybody.
Are you in BG?
I have a Mommy office and a Fremont office. I'm not in BG,
Okay,
but we can make it work.
I'm in Perrysburg, I'm closer to
Oh,
mine.
there you go, there you go. Linda,
So I would just like to add, so I'm with Over the Ohio Living, but I was previously at work in a nursing home for 28 years. And yes, we saw a lot of families that were not ready, or people that got there were not ready, and things like this, everything he said happened. You end up not knowing what to do, not knowing where to turn out, and then when your loved one dies, you end up not knowing where mom or dad are gonna have their funeral, everything is so like up in the air, and you're trying to deal with death, but trying to fix everything as far as paperwork. And I also do public speaking presentations at libraries, and I have different speakers come in and educate the community. But how your presentation went, Phillip, that is exactly how it should be. It's very simple. You got pretty much a play-by-play, and if you're willing to give us free compensation, I think that's
thanks.
I've had several people go to their lawyers or estate planners, and they are, doing things to get things in order. So the best thing to do is at least get a free consultation with whatever way you want to go.
Where you go to, like I said, I just want to make sure the idea is to raise your consciousness about this. Is this something that I should be getting done? Because once again, icky, right? We don't want to talk about it. So this is an opportunity for you to say, yes, I want to get this taken care of, whether it's me or whoever's currently working with you. If you have an attorney, that's fine too. Make sure we talk to them and have them review this stuff for you and make sure that you can sleep well. Because really, the stuff, all the odds and ends that can be overwhelming, but it's really peace of mind, right? It's I can sleep well knowing that I have everything I need set up and not have, well, Linda, the pieces we have to pick up sometimes when, and this is you giving a gift. You talk about Christmas for your kids and grandkids. This is you giving it to your family. I'm getting this done so it doesn't have to be a burden to you. I'm going to gift you with this knowledge, this information, this authority, so that when it does come, I can focus on either taking care of you if you're sick or taking care of the nursing home that occurs. And when I'm gone, I can breathe free from the worry about all these odds and ends. Because that's the hardest thing when I post them in for a state administration and they're already fighting and bickering and things are not set up and it's a mess. But on top of the grief, you're dealing with a mess to deal with. And that's really hard on the family. So if you can, anything you can do to take that burden from your family is a gift that is worth a whole lot. And I know you're not going to be here when it happens, but trust me, I see it on the other end. That it really, these families who have things set up is very beneficial.
I thought I had it, but you brought up a lot of things.
And it could be what you have is okay. That's the other side of it. I'm not, we just got to see what you got and see if it's worthwhile and you get to make a decision. I don't want you to feel like you're overwhelmed with the thing. So there's a lot in there. Some of that may not be important to you at all, but let's think about it and talk about it. And I'll poke you again. Hey, is it? No. And I want you to own the decision you make as to what you have.
Another question over there?
Can you have, a different power of attorney for financial affairs than you do for the rest of it?
Absolutely. Well, for financial versus healthcare, sure.
Okay,
I have folks who do that where they say, I know our next speaker will probably speak on that a little more, but you can have, I have folks who have children who are in the medical profession and feel more comfortable having their son who's a doctor be the healthcare person, and their son or their son or daughter who is the financial person. So yeah. You just want to make certain that we're doing that for the right reason. And it's easy to get a hold of them. If they're serving in, if they're a medical person in Europe, great, but they're not gonna be able to get a hold of. So just make sure practically you got somebody who can reach it.
All right, Charlotte?
Probate. What is the difference between having probate and not needing probate?
So if you have to go through probate, typically probate costs anywhere from 3 to 5% of the gross estate to the probate court. So it's more expensive. Every piece of paper that you file, there's $200 to file. There's any sort of cost to submit any sort of filing, that is all that money. At the end, the executor fees are higher, attorney fees are higher, and you also create a form for fighting. If you avoid probate, you don't have to sort of any of those costs.
Okay, so no probate, how does that work?
Well, no probate, typically if I do like a trust administration it's usually 1.5% is what our fee is. So significantly less
Okay.
if you go through non-probate.
You go through probate with the lawyer.
It typically should, you can, but the law allows you to do your own stuff.
I mean, if he's already done all your paperwork,
Well, no, because remember, it's still gotta be probated. The will's gotta be admitted to probate,
the lawyer will do that.
Yeah.
He will,
and they'll charge you for it as well. So
Right.
it's not like you did it once and I'll never have to pay another fee. So the distinction is, if you do that work through probate, it usually costs more, takes more time than it would otherwise.
okay,
But there's more oversight for the court, but it's also more time consuming. We have a situation right now where I've contested a couple contested probates where every time we have a hearing, there's a bill for $200 from the court for the time set aside. Well, that gets added up. So if you can avoid that, if that's what you want, you talk about it. If you have to say, well, it's straightforward, I don't care, I got one child, I'm leaving everything to, maybe you want to do a beneficiary designation or do a will. Okay. Then we gotta wrap up, right? So I don't want to.
Oh, you're good. Yeah, I'll let you know.
If we have, if I have a general, power of attorney that covers, financial, but I know it doesn't cover healthcare, but, the statutory form, does that mean the same thing as a general?
Yeah, it is. It's a statutory form. The issue is, I don't know what, I didn't provide these, so these aren't mine. So these statutory form powers of attorney, mine is just a packet of that. The next person has got those. So she'll explain that. She'll explain that more fully when you get there. It's a statutory form, so there's often check boxes and initials you have to do for some of that stuff. The law changed a few years ago, so it's good to use a statutory form, or we have it where we've actually updated it and incurred it and kind of put it in our documents where it's laid out much more clearly. So we not only have the checkbox, but all the explanations for each one of those so that our clients know what they're checking, what they're initialing. But yeah, that's a good start to get things. If that covers you, that's okay too. But you want to make sure you're using that. That minimum, the statutory form, minimum. Because you want to have the powers that you're allowed under the law. And certain powers have to be laid out properly. If they're not, your kids can't use them.
But
Or whoever.
it just says general, that
Yeah, that's
it
okay.
covers the same thing.
For this document.
All right, question here?
What is the process of changing a will with trust?
Well, it depends. Well, that's the lawyer really answer, of course, it depends. But the idea is, so first I talk about whether or not probate avoidance is something we want. Are we protecting interest for heirs? There's different types of trusts that do different things. So for us, it's basically a start over. Because not only do we create the trust, we do what's called funding. We put the assets in the trust to make sure that when it's done, the box is all secure. And so we don't just say, here's your trust, go fund it. We walk you through it and get it in there. But there's a fair amount of heavy lifting, and it's basically it's a redo for us. Yeah. And you can't say, well, I did the will, so no, for us, it's brand new. Have you got a question?
So what is it that we're avoiding with the probate again?
Cost, expense, and time.
And when my mom died, she had a will, not
That's right.
a trust. And I don't know, my My brother has the power of attorney.
Well, he was the executor under the will.
Right,
Power of attorney died with you when you had one. So.
okay. So I don't know anything about whether the will have to go through the.
It has to go to the probate court and be admitted to the probate court and approved by the heirs who have authority to do so. It's gotta be, blessed by the court. And then it gets admitted, and then you have to do an inventory, and all the assets have to be laid out. And every step of the process has to be the probate court. And so it's a very public process, and it has its own time frame. Now, the probate court's good about kicking in the tail to make sure it gets done, because they have deadlines you have to meet, but it still can go on for a long time if there's disputes or arguments, and the court has to have hearings about it. It can be really, really difficult. Or it may say, hey, we've got one heir, and it's really easy. Once again, it's a matter of, I don't go to one side or the other. I do will plans all the time. I use lots of trust. I have a trust personally that I use, but some folks, the better fit could be a will. But we're gonna, once again, we're gonna talk about it and make certain they're comfortable with this. So there's none, so when you decided, I decided this because I know that's best for me, and I'm okay with that. I'm not somebody who's gonna make you feel having to do something else if you don't want to. We'll discuss it, make sure you own your decision.
So your executor, they work with the lawyer.
Typically what you do is you'll have the lawyer helping oversee with the work of the executive.
Okay.
But the executor can take a fee, the lawyer can take a fee, and then you have all your court costs. And some folks say, well, it's not that big of a deal because my estate's not large enough to warrant that. That's okay too. But sometimes I say the probate a car is more of a hassle than probate a big estate because there's nothing there. You're probating this tiny asset and having to pay for all these costs. I mean, cars are the worst because sometimes you're a single person with a beat up car and you got to transfer the title over. You have to go to the probate court to get it. And you're paying all these fees to deal with a car that's worth, $100. Or junker car. I just did a Medicaid case, and then I'll close. We're working a Medicaid case. This son, he went to his dad got junk cars all over the place. And half of them were titled, half of them weren't. We had to find every title or get someone to sign off and say this was scrap to show the value so we could help file for Medicaid to help protect assets for this family. But every car had to get dealt with. Now, he's very happy because his dad's now going to be in a nursing home and safe and secure. When his dad dies, those cars are now out of the storage. But can you imagine if his dad passed away and he's got a property with 15 cars in various states of disrepair and has to probate them all?
You put a POD car.
TOD, but you gotta have the title to make sure you have everything set up. You can do that, sure. It's one of those you can short circuit the probate process by doing that. So you gotta make certain the outcomes are what you want. So I can tell you that outcomes for everything. And then you can decide whether that's right for you. That's it.
I have a living trust that's 13 years old.
Okay.
My wife passed away 6 years ago.
Okay.
I have issues. I want to change, a few items on that. What options do I have?
So you typically if you're new to me, we'll do what's called a restatement, where I do the entire document. Why? Because I know all the pieces because I do them, and we have to update the whole thing and restate the trust. You can do that and take your wife off the story, especially with the real property. She may still be on the trustee if you ever want to sell the property, could cause headaches down the line.
Yeah.
And then what you do is you may discuss at this point, I'm on by myself. Is my son or daughter or cousin down here? I want to bring them on as a helper right now, as a co-trustee, or am I not ready for that? Do I not want? And that's a conversation when we lose a first spouse, we often have that conversation with clients.
Okay.
Is it ready for your son to get a promotion
Okay.
or not? Because we want them with us in case something happens. I can step right in, or you know what? I have clients who are happy to be on top and they're in their 90s, they're perfectly capable and don't want their kids involved until the doctors say they can't do it anymore. And that's okay too. But these are issues you can talk about. But I would never amend. You can amend trust too. I don't amend other people's work because I don't know what their goals are or what they set out. So I would review the whole bucket. We would have to change any of the funding. We don't have to take stuff out of account. We just change all the in-years of the fund.
Yeah, okay.
Something that we do right there. Are we okay on time? Okay. So any other questions? Well, hopefully this was helpful and beneficial. Thank you for your time and attention. I'm thankful to have such a roof. And this building is amazing. I've not been here before. So I was thinking about the old building when I used to go over by the library. Now the library's not even there anymore, it's getting done. So I was getting ready to come there and I had to double check. Walked in, beautiful facility, but thanks for having me, and I'll stay.
All right, My name is Elizabeth Geer. I'm practice here in Bowling Green. I practice with my father, Norman Geer. We practice on the Four Corners downtown. I was born, raised here, graduated from high school in Bowling Green, left for college, came back 25 years later to practice with my father, and went to law school and became an attorney. So after raising 2 kids, I needed to go back to work to rest. Get some rest.
If you don't mind silencing your phones.
Anyways, what we're going to talk about today, we're going to talk about the 3 main documents, a healthcare power of attorney, a living will, and a durable power of attorney for business purposes. Also, I brought along a will if we wanted to just have a brief discussion about the format of the will. And if you guys want to talk about anything else, we can talk about that as well, probably anything like that. So the first thing I want to talk about is what each of these documents are for. The durable power of attorney is to be used while you are alive to give somebody else, it's an agency relationship, you are the principal, you are choosing an agent. That agent is able to act on your behalf. Oh, I got to stand, can't wait. Okay. That agent is able to act on your behalf. They're able to do basically the same things that you could do with your signature. With a little bit of difference, sometimes you're going to have to show ID, but for the most part, think about all the things that you are able to do with the signature. You're able to file taxes with the signature. You're able to write checks. You're able to do business for yourself, just with your signature. That's what that power of attorney does. They're able to sign, and I'm going to go through it in more detail in just a second. And when they say a statutory power of attorney, what that means is that it was written by the Ohio legislature. A statute is a legislative written law. So it's the legislator that wrote this. It was put together, and you can see kind of some of the sponsors along the bottom here. It was put together with other organizations. The wonderful thing about this power of attorney, our office, we have our own power of attorney. It's kind of, fancy, and we like it, and we're always kind of messing with it to make it just how we like it. But the bottom line is, this has everything you need to grant someone a general grant of authority. And this is what you're going to need, and this is, and then the other thing we're going to talk about is the healthcare power of attorney, the statutory power of attorney, the healthcare power of attorney for business purposes goes into effect immediately upon signing. When you sign that document, you create that principal agency relationship. The healthcare power of attorney is somebody who's going to make decisions for you, for your healthcare, when you are not able to make them for yourself. So that goes into effect, you sign it, but it only goes into effect when you are not able to make healthcare decisions for yourself. And it spells out what your wishes are going to be. It also gives you an opportunity to nominate someone for a guardian if you wish. And it also designates who will be contacted, who will be those decision-making parties. And you're going to be able to name a few. And then the living will is basically your end-of-life wishes for artificially supplied nutrition, hydration, and ventilation. You want to be on the machine, you decide. It's giving guidance to somebody to make a decision when you are not able, again, to make that decision for yourself. You're going to make that decision prior, let them know, and they'll be making that decision. And then all of those 3 documents are only in effect while you are alive. And then we can talk about the will just real briefly, which goes into effect at the moment of your death. Then the will govern your assets, which you have the right to dispose of at the time of your death. We'll talk about what that means. So the first thing I'd like you to do is look at the statutory power of attorney. Each of these different aspects is covered in the Uniform Power of Attorney Act. In sections 1337.21 to 1337.64 of the Ohio Revised Code. So, if you, in your spare time, want to go home and you can look up each of these grants of power, and there will be about 1 page or more on the very specific, legislatively and legally, what that power means. They get into it very specific. So, like I said, this goes into effect the moment that it's signed. Make sure it's someone you trust. You could be on vacation and they could sell your house. That's a little bit of an exaggeration, but not really. It gives them tremendous power. And you might want someone to do that for you. You might want you might want to go on vacation to Florida, let someone else does. So that is something that can be done with this document. And actually, I use these frequently, but again, we get into the weeds. Use this frequently for real estate transactions where maybe the seller is in California, something like that. You can transact business in the county with the power of attorney designation. Anyway, so let's look at the first page here. Actions requiring express authority. Anytime you see the word express, what that means is written. So if you were specific, if you want anybody to create a trust, amend or revoke a trust, make a gift, change rights of survivorship, these are major things that you don't want anyone to do. Once you have established who you want as your right of survivorship, who you want as your delegate, you don't want them to be able to delegate this agency relationship. You don't want someone to create a trust for you without you being involved, unless you give them express authority. If you give them express authority, which means you would write up the power of attorney specifically for that purpose, no problem. It's wonderful. They can help you do everything. But this general grant does not include these items. Okay? The first thing that you're going to do, and what I'm going to do is we're going to go through and you can fill these out if you like. I have my notary stamp back there. If you have a driver's license, I can look at it and see if it's notarized. You can be out of here with these notarized legal documents. If not, you at least have a template you can use to do your own have your own understanding of what these mean. Get them to an attorney at some point, or not. Just have them for yourself. But they do have to be notarized to be legally enforceable. Okay. So page 2 of 6 of this, right under the express authority, is the designation of the agent. Here it says I. That's you. Put the name of the principal. Again, you are the principal. This is a principal-agency relationship. Any principal-agency relationship contains the covenants of good faith and fair dealing. There's also a heightened fiduciary duty where your agent can only act in your best interest. And they cannot act in do anything that conflicts with your best interest. So fiduciary duty, being the power of attorney, picking an agent and having somebody be your agent is a very serious relationship. It's a very important relationship. It's a very useful relationship, but it's very important and it's very serious. But it's somebody who's going to do what you ask them to do. Because they don't have any authority except that which you give them. And another thing that's very important to understand is that in this principal agency relationship, the authority you give to them does not diminish your authority. Even though they have the authority to sign things on your behalf, you still have all of that same authority. Okay? It does not diminish the authority that you have. That's important to remember. So if you're filling these out, you would write your name here. And then you would name your agent. Put your agent's address and then also the agent's telephone number, because when push comes to shove and somebody has nothing but this document to know what to do, they're going to call the agent. Phone numbers are very important. You can put an email for that. The address is important too, but I'm not, And then what they have on the next page, page 3 of 6, is they allow you to name successor agents. You're not going to have multiple agents all at once. What a successor agent does is they are able to step in if your original agent is unwilling or unable. Maybe they're out of town. Maybe they've predeceased you. Maybe they're on vacation. So you want to have a successor agent in place. You don't have to, but it's always a good idea if the original person is not there. So that's your successor agent, and then your second successor agent. They do not have the authority unless the person you name as the agent is unwilling or unable. So it's not like you've got 3 people out there or 2 people out there can do anything they want. You have 1 person. And if they're unwilling or unable, it will go to. Okay. Then you get down to the grant of general authority. So here it says I grant my agent and any successor agent general authority to act for me with respect to the following subjects as defined in the Ohio Revised Code, section blah, blah, blah. Each one of these has its own code section. Real property is 1337.22. Tangible personal property is 1337.23. So each particular grant of authority has its own code section specifying exactly what that means, so that there is as little bit confusion as possible when you get to the law. So here, real property. That is a general grant of authority to do business in regards to the property that you own. Real property are things that are on a foundation, they don't include trailers, campers, mobile homes, things like that. Real property is a home on a foundation. Tangible personal property, that's your stuff. Stocks and bonds, commodities options, do banking for you, they can sign as power of attorney, insurance and annuities, estates, trusts, and other beneficial interests, which means they can manage with this general grant of authority and not necessarily establish or amend. Claims and litigation, personal and family maintenance, that might mean paying the bills. It might mean paying the utility bills of your house while you're in the hospital or something, whatever it might be. It goes on. Taxes, they can do your taxes for you and sign them for you as power of attorney. It's wonderful. The one that I usually have people initial is the one right here that says all proceeding subjects. Unless you only want to give them something specific and limit their general authority. Otherwise, you would put your initial on that all proceeding subjects line. And the one after that says that my agent shall have access to the content of electronic communication sent or received by me. That is wonderful. That means that they can get into your computer, get into your password, get into your account. I can't even tell you how many times entire universes of finances and information is lost because you don't have passwords. Or you don't know what the account is. You can get them, but if they can have statutory authority, you've given that information. That's a wonderful gift. And I like how I heard Phil use the word gift, because that's kind of the way I think about all of these documents. It is a gift to the folks who are going to be using them to take care of it. It really is. So here we have the next, after that, so usually they have folks, initial these bottoms here. And then any limit on agent's authority. And you can put special instructions if you have any there. Oftentimes, if I am doing something for real estate, I might put the parcel, real estate, the legal description in there, and then it's recorded with it. Something like that. The effective date is effective immediately upon signing and being notarized. The signature is not valid unless it's notarized. And they give you the option to nominate a guardian. If it becomes necessary for a court to appoint a guardian of my estate or my person, I nominate the following person. That is also going to come into play in these other documents. If you have a durable power of attorney, what it means is that durable is that it will withstand incompetency. Once you are incompetent, you do not have the power to contract. Once you are incompetent, and that means different things for different documents, honestly. But once you are incompetent, you are not able to contract, you are not able to give your authority away. But by signing it when you are competent, this will survive incompetency, disability, whatever. That is the wonderful, durable nature of the power of attorney. This is a very important document. You don't want a guardian. You don't want your stuff to be lost. It's a very important thing to have this. And I'm not saying that that's I must, say the very important word here is it depends. Everything on all of these are very fact specific, and it depends on your individual situation. As far as if you're going to need a guardianship, maybe you need a guardianship for other reasons or something like that. So I'm not saying anything is completely definitive, but at the same time, this is the document that will alleviate the need for you to have a guardianship for the most part, for most things. And if you want, I can talk about a guardianship looks like that. So that would give you the opportunity to nominate a guardian of your estate if you wanted to, and then also nominate a guardian of your person. A guardian of your estate is your property, your assets, your bank accounts, your tangible and intangible property. your money, your stuff. Guardian of the person is when you're on Medicaid and you have no earned income. If you have no earned income, you'll have guardian of the person, and there are different requirements. When you have a guardian of the estate, it is important that the court oversees the management of your assets and the distribution of your assets to you. So, this is just different. Talks about reliance on the power of attorney, it's valid, unless somebody knows or has reason to know that it's been invalidated. You can invalidate it, you can revoke it just as fast as you can put it into effect. It can be revoked with a signature, it can be revoked with intent, you can rip it out. And then also you can use a copy of it. That's something that every once in a while, I'll get a call from a bank somewhere and they'll say, we need an original power of attorney. And I'm like, I'm in Ohio. You know, I'm looking at the original. I have it right here in my desk. I'm the attorney on the thing. I'm looking at the original and they'll say, oh, okay, you know. But at the same time, they should use the copy. Sometimes they want to double check. So that's just what that's about, is that the copy will be just as valid as the original. And then here's your signature and the acknowledgement. Your signature, the date, your printed name, your address, your telephone number. This at the bottom, the second is acknowledged before me on 1st of February 20. What's wrong? You guys all have no idea on that? This is 2023. And that's where the name is. That's what we're trying to say. Page 6 of 6 is very important to keep with the rest of the documents, because when you're putting this with the bank, and oftentimes if you do have a power of attorney in place, you're going to want your bank to have it on file. You might want your different doctors, your different financial representatives to also have they're going to have all the pages. Even though this just is about the duties, it's important that the whole document be set together. So page 6 of 6, that's some, you know, fun reading. But that is a complete document there. Any questions on that before I move forward?
Is this something where, you create one of these and then you also give one, a copy to one of your family members, or they just have to know about it?
Before people leave my office, I say, how many copies do you want? Because we're sending them out. Sometimes people don't want to send them out just because it is a huge grant of authority. Sometimes they just kind of want to, you know, keep their cards hidden a little bit, but absolutely, they have to, if somebody doesn't know about it, they can't step in and take over, or can't exercise authority that they have. So it's very important, yes, if the people that are notified, I mean, at the very least, would send one to everybody who is on there as an agent. Of course, your agent, and then you successor agent. But again, if you, like I said, that just goes into effect immediately, so it kind of depends. You can at least let them know it exists. Yeah.
When I took the, durable power of attorney to the bank, so that my son would be on the account, they would not do it and without him being present to sign it, and they had to have his birth certificate and then driver's license.
And that was,
That was funny.
sure, so to put him, honestly, each bank's gonna do what they want, and it's gonna change every few months, honestly. So what's your experience? You know, what do you think about that?
My experience is, you know, banks have their own rules for adding folks to the power of attorney, but, you know, I think what happened is they need him to be added as a power of attorney to your account with the document. So they want to know who he is and what he's doing to protect you. So I'm sure they want to do a little check on having an ID form and him to sign off so that they know who's helping you, so that they're protected, but also you're protected. So it sounds like a.
And they might need to do a signature card or something like that as well, but it shouldn't, you shouldn't necessarily need any more than the power of
And
attorney,
it's a matter of
honestly.
what that bank.
Yeah.
Well,
Yeah.
and also just to add to that,
Sure.
ever since 9/11, the banks are more out to ask you for more information, just to make sure that you're not into terrorist.
I'm laundering money.
Yeah.
That's part of it.
For me, my son had to be there and sign and show his driver's license during bank stuff. And the same thing for the last time. He has to sign that part too.
Okay, so that's kind of the internal signature
But it
thing.
was the birth certificate that was.
I was gonna say, that seems a little, that seems like a bit much, but But yeah, you never, I mean, you never know. Yeah, again, it does.
I'm a notary and it used to be, but this is when I first got the notary, that if I know her and I have her identified, the fact that she says he's my son, I'm able to take that word from her. But I can sign for people, like the example in class was, if this lady comes in and tells you that she's budgeting for her friend who's in bed and can come herself personally, that as long as I have all the identification from her, that I can take her word about the other person. At least that was.
That's not my understanding of the notary, but I'm not gonna really address that because I would be so nervous to do something like that, honestly, but I'm not saying that that's
But
not
I'm sure,
possible.
yeah, I'm sure the banks are gonna have more, they're gonna
More
have the
stringent,
actual-
right?
Yeah.
And basically, if you read the thing, it says that you have to, know. Known to me. Actually, this one doesn't have the big thing there, but oftentimes I can say that if I know them, but it's important, my secretaries had to go to the most recent class, you know, it was just a couple of years ago, and they were very much supposed to the drivers. So that's kind of what we do now, is that we have to look at a driver's license, unless it's somebody who's the client, I've already seen their driver, you know, that kind of thing, just because.
Sorry, could I add also, in case you happen to have Alzheimer's and if the bank wasn't to ask you for that, anybody can go over there and just say you have Alzheimer's and I say to the bank, Mom wants me to know I'm her power of attorney, so I can get into everything. They don't ask me that, they wouldn't be able to see that under active daughter. I can take advantage of you or put they in front. And you got Alzheimer's, you don't know any better. So that would be another.
And that happens.
No, I would ask for her friend's driver's license. I always do it.
Yeah, so, and again, it's just a matter of,
I
and
thought if he had a copy of the power of attorney too, that would do. With a driver's license or something, but it didn't.
sure, no, and you got, you know, and again, like, it's just kind of what they want, and, I know at one point, I was going back and forth with the bank in Illinois, because they didn't have page 6. They were like, the document's incomplete, I'm like, what's not there? And they took it when they're like, we don't have page 6, I was like, okay, thank you.
Actually, or the email scan.
Or it will never happen, but there's nothing even, you know, specific on page 6, but they want to have it specific. So, okay. You just never know, and that's why, you know, it's nice to have an attorney or somebody working with you, familiar, just because don't be smelly. Nobody welcome people to it. Okay, any more questions on the durable power of attorney? I'm going to move on to the healthcare power of attorney. Yes, sir.
Can you have two people on the power of attorney? Or just-
Yes, you can. You can have co-agents.
Okay.
Go ahead.
Oh, go ahead.
Okay, unless there's a good reason, sometimes it can be cumbersome, right? Because you have to have both people sign at every time. Just like when you do a will, sometimes people want co-executors, sometimes they want co-trustees. Sometimes it's very doable and very, you know, easy. Sometimes it becomes very awkward and cumbersome. So it really just depends. Because everybody would have to, both people would have to sign.
Mhm.
So if they're doing some kind of activity, both people would have to come in, both people would have to sign. Sometimes it's an issue, sometimes it's not. A lot of times, if you do have two people that, you know, are kind of equally involved, they want to be successful.
Mhm.
So that they can always step in if the other person, like I said, is unable or unwilling, and if they have a good working relationship, they could kind of cover everything. But that said, if it does become a situation where you feel like maybe you need co-agents, that can be done.
If one of them's out of state, can they do that electronically somehow, or you have to have, if you had two people on it?
That's part of the issue, right, is that that's why I think the successor works a little better, because then you're not just you have to have the two necessarily, if one of them is available, what
They have
either
to be
or.
there in person.
Well, it has to be the original agent would have to be there. And if you have a co, they would both be there. And again, when you're talking about like a trustee situation and you're a married couple, it makes a lot of sense to have co-trustees, you know, or spouses or you know, whoever owns the trust. That makes sense because you're a person. Well, if they're signing, you want to make a decision together. After that, you're going to want to have
I don't know if this is an old law too, because we had this a long time ago. But they said that an executor to a will have to have a good credit.
Good credit rating.
Is that still an issue or not?
I have never known of any court checking an executive's credit. Maybe if, have you done that?
They do the background checks for guardianship,
Correct.
but not for executives. I never.
And the background checks for the guardianship is actually ECI, it's the criminal stuff, so they do a criminal, local
I've never
entity.
seen a credit check for executives. It's not a bad idea, just be.
It's not a bad idea, honestly,
Idea for
but,
some of the folks who've been selected in my past experience, but.
yeah, it's not a bad idea, but no, they haven't done that. Okay, anything else? I'm gonna move on, and we'll get. So, next thing I'm gonna talk about is the healthcare power of attorney. And that it comes together in one packet. Again, this is a statutory form. You can see all of these, was written by the Ohio State Bar Association, and then the next page, you can see all these different medical associations. The Ohio Osteopathic, Ohio Hospital, Ohio State Medical Association, et cetera. They wanted to make sure that everything that they needed was in this form. And another good thing about this, thank you. Another really good thing about this form is if the hospital has this form, which it should be on the file at the hospital, your doctors, they know where to find the information. When they need it, they know where to find it. They don't have to go looking through, the different power of attorney, they're looking through your personal documents. The statutory form lays it out, it's a standard form, and has all the bells and whistles. And it's not as bad as some of the forms. Some forms are just government forms. This one covers everything. Okay, so the first page here, you can see that they have the state of Ohio Advanced Directives, Healthcare Power of Attorney, Living Will Declaration. And you completed a Healthcare Power of Attorney, yes. Did you have special notes? Maybe. Did you include a nomination guardian, whatever? Have you completed a living will? Yes, because that's what you're going to do after this. That's what we do. The Healthcare Power of Attorney, this is the one that will go into effect when you are not able to make decisions for yourself. You're not able to make medical decisions for yourself. So it's going to be important to use somebody that is familiar with your wishes. If they have a medical background, wow, that would be great. Or somebody that could advocate for you in a medical situation when you're not able to advocate for yourself. And while you are able to advocate for yourself, you make your own decisions from this document. You don't write the signs in place. You're going to be making all of your own decisions until you are not able to. Okay? And that's important. And maybe it's just a situation where you've gone in for surgery, you've come out, you are under sedation, they need to make some decisions about what to do next. This is the person they're going to talk. The person on your healthcare power of attorney. During COVID, when you only allowed to have one visitor, there were all these restrictions. This is the person that's going to. So, this is for you to write your full name and your date of birth. These are all the different definitions that throughout this document. The ones that are important here are the artificially technologically supplied nutritional hydration, basically that's food and fluids provided to your surveillance and food feeding. Comfort care is any measure of medical or nursing procedure that is to diminish a patient's pain, but not necessarily postpone death. CPR and the CPR is a DNR. This is not a DNR. This directs your doctor to issue a DNR. Only a physician can issue a DNR. You know what this is. But this asks them to do that, but this is not that. It does ask them to not do the CPR only. There's another definition. This is another one that's very important, is the permanently unconscious state. It's an irreversible condition in which you are permanently unaware of yourself and your surroundings, and you are not likely to recover. And 2 doctors have to say that that is the case. So, not just any one individual can come in and make those determinations. It has to be made by 2 doctors that say that you are either in a permanently unconscious state or in a terminal condition, which means irreversible, incurable, and untreatable, and that there is no recovery. Death is likely to occur shortly. So if they are able to state that you're in those conditions, like I say, it has to be two positions. Next page, page 3 of 12. Is the naming of the agent. The person below is your agent. Put their name and then also put the relationship to it. If it's a friend, if it's a son, if it's a daughter, cousin, spouse, whatever it might be. And don't think that your spouse is going to be able to just have free reign to your stuff, because there are situations where they do not. I've seen situations where they have been very open and given a lot of information to the spouse, and I've also seen the exact opposite. So I wouldn't risk it. You need to have your, if you don't have your spouse as the first person, that's, they need to be the first person on it. Of course, if they're the people that are going to, you want to depend on at that moment, right? So you name your agent and then the relationship. Again, address, phone numbers, and phone numbers. The next box there, by placing my initials in this box, what you are doing is you are allowing your agent to access protected healthcare information. This cuts through HIPAA. Even though in that durable power of attorney and all of those things, it says that you have access to all that information, they don't want to give it to you, and they start, saying HIPAA. I don't know how many times I've heard that. This will cut through that faster than anything. Not that the other power of attorney will cut through it as well, but this is specific to HIPAA. My agent can obtain protected healthcare information immediately and at any future time. Don't put them in the hospital. I can't get overemphasize that. And then here, guidance to your agent. Basically, hopefully you've had a discussion with the person that you named as your agent. A discussion about what you want the end of your life to look like, or what you want if you're going in for a particular procedure. What are the likely outcomes? You'll have a conversation with your doctor about the likely outcomes. And then you'll want your healthcare power of attorney to know what your wishes are based on the different scenarios, so they can make the decisions. You can put instructions in this document or to be otherwise known to them. Basically, this document is just saying what you don't want. Tubes and machines and things like that. It's also naming, of course, the people. And then here, my agent, if you don't give them information, if they're not sure what's going on, they will have to determine it to the best of their ability, with your best interest at heart, using good faith, honesty, and fact, exercising their fiduciary duty with no conflict of interest and acting in the best interest.
I do have a question about this guidance to agents.
Sure.
If I understood you right, this is where you can add things that you don't want, that aren't necessarily on page 2. No. I think where I'm going with this is there are things that it says that the DNR is only to stop cardio. What am I saying? Where's the thing about the
It's right here,
Page
page 1 of 12.
1, okay. Oh, yeah. The do not resuscitate or DNR order means the physician's medical order that is written in the patient's record. That the patient should not receive cardiopulmonary resuscitation. Is that the only thing the DNR is good for? And
I think that the DNR is probably more than that, but I'm not a doctor and I don't want to.
There's 2 types. There's a do not resuscitate cardiac arrest. So I have actually some sheets, Danielle, I can bring, if you guys want it, if it's okay with you. They're just pictures of the DNRs, the different types.
Okay.
So you either want the one that says do everything, full code, I mean, do everything you can in your power to get to keep alive. Then there's a not resuscitate, discomfort care, light, compressors, whatever. And then there's do not resuscitate cardiac arrest, where they're actually going to try to work on you and then send you to the ER. So there's 3 different kinds, and then there's pictures on the paper that you can see the explanations of them. So there is a difference. There's 3 types of things you can do. One of them is full code, help me. The other one is kind of medium, and the other one is just keep me comfortable here, wherever I'm at.
Okay, so those will not be done with this document.
Right. There's
Those are-
another special
Well,
document.
the doctor has to write this. This is just written by a dumb.
the doctor,
I'm sorry,
right.
you don't know. I'm sorry.
Right,
The doctor has to make medical decisions.
Oh, I understand that, but,
No, so,
okay, so the guidance to agents, that's
Okay.
where my original question was coming in. Can a person add things somewhere, somehow, that isn't included in these documents?
Yes.
Where and how?
I'm looking to see where that's gonna be. Well, there will be a place in the living will. I'm not sure if there's, I'm looking here in the healthcare power of attorney. Okay, bottom of page 5. And it says additional instructions or limitations. And so then I give additional instructions or impose additional limitations on the authority of my agent. Below are my specific instructions or limitations.
Where,
You can
where
get-
are you? You're.
I'm on the page 5 of 12 at the bottom. There's a box, an empty box.
Oh,
It's right, the paragraph right above that. Right before that, it talks about the limitations of the agent's authority. So we're on page 3. Let's get there, okay? Let me just hold
All
on
right.
thought and then we'll get there. So we've got the, we're talking about the guidance to the agent. And then when you name your, so you've named your agent at the top of page 3. And just like in the durable power of attorney for business purposes, or the statutory power of attorney, you're gonna wanna have an alternate, because what happens? Your agent might be out of town, your agent might have previously, your agent might be doing something else. You're gonna wanna have an alternate. The alternate is, and the criteria for the alternate to step in is unwilling or unable, that your original agent is unwilling or unable, or is not immediately available. Immediately available is going to be very important in the context of the health.
So does that mean like physically available, or can they call them on the phone and get?
They can call them on the phone, absolutely, yeah. They can contact you, they'll have your phone number, and that's the initial contact that they'll make. Sometimes being in person is just not feasible. It's optimal, but not feasible. So it depends. Okay, so you would put your first alternate, you have a first alternate, and you can also name a second alternate. And that will go in that, that's a hierarchy. Your agent will be the first person, then your first alternate, and then the second alternate. So, again, like I said, you're not gonna have all three acting at the same time. Then you get the powers. This next page, page 4, is nothing but authorities of the agent, the things that they can do. They can consent to obtain meds. They can execute releases accordingly to obtain medical related information. That's what they say. They can select, employ, and discharge healthcare personnel to provide home health care. They can pick the nursing home. They can make sure you get the treatment that you need if you need to go into a rehab facility. They execute consent and waivers, releases of liability, all of those things. Okay, now we get to page 5. These are and the special instructions at the top. It says these instructions apply only if I do not have an active living will declaration. I just always had people initial them anyways, because what if they don't have the living will? But they should, because it's all just kind of one document, but it's belt and suspenders. It's just duplicative. It doesn't negate each other. So by putting your initials in that box, you're authorizing your agent to refuse artificially supplied nutrition and hydration and ventilation. And if it's already started, you're authorizing them to withdraw. So that's huge. But at the same time, that's what most people want. After living a good life, not the way that, it's all about you and what your decisions are. And that's the important thing to be reflected in this document, is what you want to have done. Because it's all about you and making sure that people that are going to be doing it know what you want done. Because that's what they want to do. They want to do what you do. They don't want to have to make these decisions in a vacuum. They want to make sure you guys and do what you want. Okay,
Even if we're concerned to, you know, we can go ahead and this.
yes, I would say yes. There's no harm to it. Like I said, it makes me nervous. What if the living room isn't attached? So it does the same thing as it is. Anyway, so then the limits on the authority, you don't have, your agent is not going to be able to, end comfort care. Palliative care, they're going to keep you comfortable, hydration, all those things. Things that they do, during compassionate end of life treatment, they're not going to be able to just draw that and say, put it on the back seat. The agent cannot withdraw, any of the life-sustaining treatment or the artificial hydration unless two physicians say that you are in either of those two situations, terminal condition or permanent mental. Now here at the bottom, the additional instructions and limitations. In your healthcare setting, there's something very specific that you need, and you want to be sure of that is paid attention to. You're going to put it there.
Like what?
Variance frequently that people put stuff there, but I have had folks that have dietary restrictions, and they want to make sure that those are honored. If they're not conscious, they're not able to refuse certain types of food, or if they are getting tubes to use and things like that. And then, but they would put that dietary restriction right there, so that would be considered when you go with the healthcare. That's pretty much what I've seen people do there. Things that they want to make sure happen in the hospital or in the nursing home. So. It is no law.
I think there was a lady from hospice who did a presentation last year, and she said she doesn't like silence, so she even put down the kind of music that she wanted to play.
Something that nobody you might not know, you want someone to know when you can't tell it. Like I said, like if you have a restriction, you don't eat certain things, through religious purposes or whatever, or you want to make sure that that's honored. Like you said, if you want music, special instructions. I think that's a great idea. I mean, I think whatever it's not. How do I say this? It's important to have there. Are they going to make sure and effectuate that? At least the person who's advocating on your behalf is going to know that you want it. Are the people looking at the document going to look at that and say, "Oh, what's all right"?
I think you can bring in some kind of a music maker or whatever and play that music for them, right?
Absolutely. Absolutely. And a family has all this, and I would say, let your people know. Let your people know. And it's who has not had the conversation with their people? Don't be shy. Okay. What helps opening up the doors? People that have had that conversation, what helps? What helps getting the door open to start that conversation?
I've always been very open with my kids, and we talk about, this is gonna happen if I die, you understand, oh, look at that, they didn't have this, but I do.
Okay, so that's been kind of a continuation of an open conversation, where some families like, I don't, you never talk about money, you don't talk about stuff like, you have no idea, I mean, you just don't.
In my case was the death of one of my sons.
Oh, okay.
Of course, the thing that what happened, it was something unexpected. It was a tracking accident, so it was an illness that we were
Caught off guard.
It was instant 31, no reason to die. And so that caused the conversation with my other son as to how to deal with it.
Yeah. So, and oftentimes that's what happens. People will be like, "Oh my gosh, I went through this with my spouse-in-law, and it was a nightmare, and I don't want that to happen with my kids." Or sort of, but whatever it is, it's important that they know. Because if they don't know, the more they don't know, the less secure they're going to be and the less comfortable they're going to
Well, they
feel.
have to be receptive too.
Yes, they do have to be
They
receptive.
can refuse to have the conversation, which is
Well,
what
then
I
you just
do.
put the documents on there, you send them the documents, they get them in the mail, they know they're on board, they're on call, they're on deck.
I think one thing that helped With my kids, I didn't really have any trouble with it, and I know some do just shut down, they don't wanna think about it.
Sure.
But by making it really plain how much easier it was with my parents, because we knew exactly what they wanted when they had to do the deed not resuscitate. They made it very quick, and it's still a horribly hard decision to make.
That is the bottom line. It is a horribly hard decision to make.
But if you
But
know
with guidance,
it's the right thing, it's still hard,
right,
but it's a lot easier.
okay.
And
that's-
by emphasizing that, I think it helps open up a lot to talk to about yourself and your kids.
Sure, and that is the bottom line. And it's gonna be difficult regardless, and like Phil kept alluding to, when people are involved in abuse situations, even if somebody's 98 years old, you know, and they die, everybody's just cool. Because they've been around so long. You just, even though you knew it was coming, or, you know, it's still, do not ever underestimate the effect of grief on people. Anything you can do to make things easier.
My almost 90-year-old parents are still both living at home, they're good, but they've always talked to us a little bit at a time with, you know, and for a while now, if you walk in their house and you pull any of the pictures apart, or you pick up anything, their knickknacks are just, you know, taken out of the line, but they've got the names of each one of us, there's 5 of us, of who, what's to go to who.
What a gift, so you'll be fighting with it, right?
Right.
I mean,
And that happened in my husband's family, but then the daughter just put her name on everything, so. So we're looking at her, it's like, wait. And that's great, you know, that is a wonderful thing to do. Anything you can do to make it easier, you know, so.
And I would say too, like, last summer, early fall, we had 4 pretty good friends of ours who died just real suddenly in their 60s, no known health causes. And so we have 2 children in their early 30s, and it was very easy to start talking to them about, you know, this could happen to Eric's mom, it could happen to your mom.
Yeah, no, it is, it is, that's, you know, the great unknown about all of this, right, so, anything we can do is wonderful. Okay, where was I here, on page 6? Okay, on page 6, it allows you to nominate a guardian. Just because you nominate somebody as a guardian, they don't have to accept that nomination, but this is sort of what they call non-rebuttable presumption. Unless they don't want to do it, and unless there's a reason not to, the court will appoint that person as guardian. They're willing and able and suitable, competent, suitable and competent are the criteria. Help me with the background checks, that kind of thing. So that's an opportunity to nominate somebody. This is the guardian of the person. And if you write your initials in that box, about 2/3 of the way down the page, that means you're nominating the person you named as your favorite. So, person you trust in your husband's decision, the person you're nominating as your favorite. If you don't want them and you want somebody else, you would put that below.
So a guardian and an agent are the same person?
No, they could be. What you were doing is you nominate your agent. Your agent is the one that you designated. And if you want to nominate, and again, this is just something the courts have put in here because so often when somebody gets in a situation and they need a guardianship, they don't know who to go to, or there's no one to go to. Court will appoint sometimes volunteers, sometimes the court will call, they appoint me guardian situation when there's no one. Sometimes a family will come and, you know, appoint, I'll act as guardian, or I'll act as the attorney for the spouse who will act as guardian. Yes, you have to become guardian of your spouse. If that's the situation, if that's the situation you find yourself in. So all it is giving the court some value. And again, which is, you know, what you want them to do, because this whole thing only goes into effect when you're not able to make your own decisions. So it's giving them that.
So if we initial that,
For agent, yes. Then do we cross out this bottom?
Yes, and we cross out the rest of the nominating someone else. And that's the guardian of the, estate, and then you would, okay, yes, and then you would cross that out, the guardian of the person, and then on the next page, it's the same thing for the guardian of the estate. The guardian of the estate oftentimes has to take out a bond. A bond is based on the value of their estate. To protect you and them if there's something that happens. This is by putting your initial there. Again, you are nominating the person that you named as your agent to be the guardian of your estate. If you don't want that person or don't want anybody, you don't have to do anything there. If you do want to nominate your agent, cross out the stuff below. The next box is allowing the guardian of your estate to take authority without bond. Which you should do, unless you can bond necessarily. Sometimes it is, sometimes it's not. Oftentimes, like when you do wills and things, you put in there, kind of in the template, the executor of my estate can operate without bonds. If you waive bonds for them. So that's, it gives you the opportunity to waive bonds. Because it's a lot, they have to go to an insurance company. I mean, it's important, right? And you do it if it's necessary, of course, but go to insurance companies, if you have a $200,000 estate, you have to get a bond, they're costing maybe $700 a year to insure that. Managing that custodial accounts, like mutual funds, things like that, they don't necessarily have to go through that. Okay, so then the no expiration date does not expire and it's not affected by your disability or by the passage of time. Which means your competency is good. And then page 8, you are the principal, you sign it on such and such date at Wilmington, Ohio, and you sign there as the principal. And then the notary signs on page 7. Sometimes I see folks use key witnesses on these documents. I always do the notary. So, you know, it's not going to be an issue. And then there is 1, 2, 3 pages of gobbledygook. I'm sorry, I didn't mean that. I'm at legalese, okay? There's 3 pages of legalese at the end there. If you want to read that, it really talks about the definition, et cetera, and the duties and things like that. I mean, it really is. But yeah, it is.
Our signature has to be written.
Yes, so don't sign anything, you can fill that in, and then we'll sign it, we'll sign it at the end here. Okay, now we're gonna go over the living will. It's a little shorter here, and this, only applies if you are in a terminal condition, if you are in a terminal condition or a permanently unconscious state. This is the pull the plug document. Right here. This is the one where you're saying, do it, pull it. Unequivocally. Don't even think about it. So again, your full name, your date of birth, the same definitions that you're going to see in the healthcare power of attorney. And you are intending that this living will declaration will be honored by your family and physicians as the final expression of your legal right to refuse healthcare.
So if you have the living will, you also need the, do not resuscitate. You need that signed,
Well,
or is the living will enough?
here's the thing. The living will expresses your wishes. Okay, it's written pretty much in you. This is your document. If you're not reciprocating, it's the doctor's document. It is a medical right that has to be issued and signed by the doctor.
Okay.
So it's not necessarily, they can say in here that you don't want CPR, but they're not going into detail that you alluded to, right, as far as what is really, the intricacies of the do not resuscitate order. Not something that is just a raw medical thing with the doctor. So I just don't want to speak to it. No.
Because I have to call the squad. First question of people in houses, do you have a living well?
Right,
And yes, it was on 5 o'clock there.
okay.
So then they go ahead and then do everything.
Mhm.
If you don't have that, then they're only going to do certain things, right?
No, if you don't have a living will, they're going to do everything.
Okay.
They are going to do everything. Their job is to keep you alive,
Okay.
Yeah, to give you an example.
period. Yeah.
So one of my friends, her family member, they're out in the country and part of the husband has, not, this is to say, completely, doesn't want anything done. And they're out in the country, it's about 20 minutes for the EMS to get there. And the wife comes out and she finds him dead in the van. She said, no, do that. But when they get there, they get him out and they start CPR on him and everything. And she says, no, these are do not resuscitate, just leave them alone. They can't do that because she didn't have the paper with her. So she said, well, the doctor has the paper. He's like, well, you should have a copy. Okay.
You have which paper, the living will or
Does
the?
do not resuscitate.
Oh.
It's part of your living will. Living will, you just be more specific, like the lady said, you want specific music, you want something, but, they didn't have that. So you have to have that with you also. But depends if there is 3 types of full code, you do everything. Get the EMS to get you, take you to the hospital, plug you into every tube and breathing system there is. Then there's the do not resuscitate, don't do anything, just comfort measures to be comfortable. And then there's the do not resuscitate, comfort, care, or rest. That means you give me a little bit of CPR and you take me some medication to keep me going. Looking at maybe like a little bit of breathing. So yeah, there's different bits. And I'm gonna bring a little sheet that's got like a pictures and then description, and I'm gonna give it to Danielle and you both can ask her for them, or you can have them up front. Put the pictures, make it so much easier for you to understand.
And so this is a waiver. This is a waiver for them to not do every procedure possible on you.
Yeah.
You are waiving your right to have them do absolutely everything medically necessary.
So what they do to get them to stop, to get them to stop?
So the EMS had to call her doctor. The doctor had to fax them through their, they have, laptops.
To do that.
The actual sheet, so that you can see it, because the EMS is inclined to save your life. They can't take your word for it, because maybe you don't want, so-and-so to stay alive, so you're like, oh, no, they're a DNR.
Those are a little more serious. Okay. So, but yeah, this is basically your waiver. You are voluntarily declaring that you do not want to be artificially, you do not want your dying to be artificially infused. Very important, you're dying. Living will, you could use just if you're having surgery or something like that. I'm sorry, not the legal, the healthcare power of attorney can be used if you're having surgery or any kind of medical procedure, and you're gonna need somebody to advocate for you to be able to get all these records, so they can successfully advocate for you and make decisions. This is when you're dying. And you're waiving the fact to not have your death artificially prolonged. It's basically the whole thing is a waiver. Okay, so again, we have the same kind of definitions. They talk about the healthcare power of attorney in here. It means a legal document that lets the person authorized to make healthcare decisions when you're not able to. Gather protected healthcare information, all of those things. The healthcare power of attorney is not a durable power of attorney or financial power of attorney for business purposes. Only about healthcare. And then here, you're gonna lay your, as to be a complete healthcare power of attorney, yes. Copies the same as an original, they say that you can rely on them. And also here, as a statutory form, you see a RC, squiggly line, 2123.02 C. What that means is that the Ohio Revised Code, section 2113.3, or excuse me, 2002, section 2. And that's where you're going to find the more specific legalese about that statement. Because all of these, like I said, with all of this is written by the legislature. They have written pages on every single line of the statute. And then if your doctor determines that life-saving treatment should not be withheld or withdrawn, then they'll let you know. There should be, they'll let your contacts know. So then you're gonna name a first contact and designate the relationship and the phone number. The phone number is the most important, of course. But the address is important too. If you don't know the exact street address, it's not. If you, the second contact name, relationship, and the thing. These are just contacts. You are already telling them that you do not wish to have artificial. You're waiving the right to be, have your dying from them. And then for providing comfort care, you're authorizing your physician, this is the physician, to administer no life-sustaining treatment, including CPR, even though that's in there, that is not a do not necessitate order. Withhold or withdraw artificially technologically supplied nutrition or hydration. Include special instructions, make sure they've been met. Issue a DNR order. This is not a DNR order, but it's asking the doctor to issue one. Okay? And then take no action to postpone the death. Except palliative comfort relief care. And then again, built and suspended, what they're asking you to do here is put initials in the box, if yes, that is what you want. We authorize your physician to withdraw treatment authority started when you do not begin treatment if you're in either of those situations. And here again is place for additional instructions. There's something that you know, no, at the hospital, or you know, otherwise no, or your people would not know. And then page 6, it talks about the anatomical gift. If that's something that you want to do, that is not done through this document necessarily, unless you don't have a driver's license. It's done through the DMV. You really want to make sure that your organs get donated to the DMV. Yeah.
So does the mortician do all that, or do you contact somebody if you want?
They'll have it, the DMV will, I'm trying to think of where those documents will actually go. Because it's on your driver's license, and then you'll make your physician know, they'll know that. I think they'll check that when they do the death, maybe when they do the death certificate or at death, if somebody else, that's where they go for the definitive information on organ donation is these
But the
records.
family doesn't have to contact them about it.
The coroner's
No.
office.
Well, the coroner's office usually does, you know, because that's, then they look at the, you know, they look at your license, they have that information, they pull up the stuff on the DMV, they have all the stuff in the death certificate. You know, honestly, I'm not exactly sure what the process is at that point, to be specific, I don't wanna.
I think if you have your funeral arrangement in place, you're gonna give that also information to your funeral director, because you're definitely gonna have to know about it.
I know that I don't do that as an attorney, I don't necessarily contact them about the organ donations, but I do sometimes, and I don't necessarily, I don't contact them about an autopsy either, but I will contact them to resolve.
And I thought you also go into the database.
The coroner's office, then contacts the tissue banks and things like that.
Just like at the hospital, usually somebody else takes your wallet,
Right.
if you don't have your driver's license. And
So that will be that big database in the sky where they have all the death certificates and all that.
Or if you're donating an organ, somebody knows.
Mhm.
They're gonna want, yeah, I think that.
They're quick on that.
But when you have a driver's license, you don't answer all these specific questions.
No,
You just
none of
say
it.
you want to be an organ donor.
They can take what they, based on your age, they take what they can.
Know before you die.
So you don't need something more specific like this then.
You can, on your living will put one.
Okay, and
I'm just saying that don't count on them looking at it. They're gonna look at the.
Yeah.
Just for practical purposes. Okay, and then here's the signing and the, you know, you sign, same situation.
oh,
Right.
It's notarized on the next page. And then all this stuff, go to registry enrollment form. Again, if it's something that you want to do, it needs to be done to the DMV, just to be certain when it happens. I don't know why, honestly, they put it on, you know why they put it on the form, when it doesn't even really govern
So what the,
the organ donation.
Yeah.
I think it's just because it's gotta be very thorough, so you have to have everything in place.
Okay.
But I'm pretty sure if you're an organ donor, I used to be one many years, like 20 years ago, before I saw me. But, they told me it goes into the database. So that's where I have the same question for the DMV. It's like, well, do I have to tell the hospital this? Do I have to,
Right.
so you can write it in your living will if you want, you can tell, your funeral director. But it's, I'm pretty sure somebody should go to the database. So if you ended up in the hospital, your name will show up.
Yeah, and if it's only on the living will, they won't catch it, probably, that's my guess. They won't catch it.
That's just for your family,
Sure, yeah.
not to be shocked.
Okay, any questions on that one? Any questions in general, in a lot?